Hi, today I'd like to talk about Deputy Attorney General Rod Rosenstein. He has intentionally stonewalled congressional oversight requests for documents since the day he was appointed to his position. Recently, Mr. Kevin Nunes, the chairman of the House Intelligence Committee, requested an unredacted copy of the scope memo for the appointment of Special Counsel Mueller. The scope memo outlines the extent of Mr. Mueller's jurisdiction, the areas that he is allowed to investigate. Mr. Rosenstein's response was to deny the request. Mr. Nunes responded with a statement that he would hold Mr. Rosenstein in contempt of Congress if the request was not honored. Other members of Congress, in the meantime, had circulated a document outlining the potential impeachment of Mr. Rosenstein for his stonewalling and refusals. Mr. Rosenstein's arrogant response was that the Department of Justice would not be extorted by Congress. Let's take a look.
The Department of Justice is not going to be extorted. We're going to do what's required by the rule of law.
He said that the Department of Justice, and I quote, would do what's required by the rule of law. The rule of law requires that the Department of Justice give Congress the documents they demand when it exercises its oversight function. The House Intelligence Committee has the right of oversight of the executive branch and its agencies. There are three principal legal rationales for congressional investigative and oversight power. 1, to obtain information that impacts prospective legislation. 2, to monitor the present execution of law. And 3, to investigate government misconduct. The following Supreme Court decisions support the right of congressional oversight. The Supreme Court recognizes congressional power to investigate the administration of existing laws. In Watkins v. United States, Chief Justice Warren observed that congressional oversight power encompasses inquiries concerning the administration of existing laws, in addition to contemplated legislation. The Supreme Court recognized that the power to investigate the administration of the laws is a power that comprehends probes into departments of the federal government to expose corruption, inefficiency, or waste. The Supreme Court acknowledged the pronouncement in Watkins v. United States that congressional oversight powers encompasses inquiries concerning the administration of existing laws. The Special Counsel statute is one such law. The Supreme Court articulated the constitutional basis for congressional oversight in McGrain v. Dougherty. There, the court was squarely presented with the question of whether power to make investigations and exact testimony is so far incidental to the legislative function as to be implied. The court held that the power of inquiry, with process to enforce it, is an essential and appropriate auxiliary to the legislative function. The Supreme Court has even recognized that vigilant oversight by Congress also may serve to deter presidential abuses of office, as well as to make credible the threat of impeachment. Mr. Rosenstein knows that Mr. Nunes, as chairman of the House Intelligence Committee, has a top-secret clearance that allows him to access these documents. So there's no rationale for Mr. Rosenstein to deny Mr. Nunes' request. Mr. Rosenstein, because of his stonewalling and continual refusals, should be removed from his position. He should be shown that the exercise of this constitutional right is not extortion. Well, I hope this helps. Have a good day.